Good morning, Mr. Zelenak.
Good morning, Your Honor.
How are you, sir?
I'm doing well, Judge. It's nice to see you too. And you're early, which I really appreciate.
I'm early because you're early.
I know. Well, Your Honor, if you remember anything about my career, it won't be about my competence, just that I'm always diligent at being early. We're too late to worry about competence. When you get to my point in my career, you just want to show up, and that's the best part of the day.
Showing up is half the battle, right?
That's right, Judge. I'm still waiting to come out for the grand opening of the courthouse.
You still haven't been here?
I came in and left donuts when you just completed construction, and that's the last time. I haven't had the official invite. I'm going to drive out one day if they'll let me in. All right. Well, maybe I'll come out. You're going to be there Wednesday morning. I'll come out Wednesday. I've just got one little thing, and I'll drive out there.
On Wednesday morning?
Yes. No. How about tomorrow?
Somebody's here every day, Monday through Friday, 8 to 3:30. We're open to the public.
Well, I wasn't aware of that, Judge, because I find out that there's better justice when you do it in person. There's more of an impression. But
if you're ready with your client,
I am ready. I'm going to have him close the door so we don't get any background sound in my office. I will just, because I know this is a sobriety court. Judge, do you mind if I have him on the same screen with me? I'll just turn the camera around for him when he speaks.
That's fine.
All right.
This is 22BL002850D. This is City of Belleville versus James Ryan Chichalis. May I have your appearances, please?
Good morning, Your Honor. Edward Zelenak, P27611, attorney for the defendant. He's present here, and we're going to proceed today with you via Zoom. So let's give your name to the judge, please.
James Chichalis.
Chichalis. Thank you, sir. Mr. Zelenak, the only thing is you say this is sobriety court. This is not sobriety court.
Well, no, he got accepted in a Lincoln Park sobriety court, and he's going through their orientation process. And I believe we were advised he would be sentenced consistent with them. You would sentence him, but it would be to the terms at sobriety court. I believe you get the fines and costs. And then if he messes up, you get to put him in jail.
Yes. Sir.
I know that he's in. I spoke with Judge Clifton. If you want him to allocute and tell you where he's at, he certainly will. He might just bore you to tears, but I think he's doing well there.
No, it's fine. Our probation department has checked in with 25th, and their notation to me is that he's currently engaged. Was there something you want, before we get any more into it, there was an offense date in this case of March the 6th, 2022, at which time your client was charged with operating while intoxicated. He appeared before this court on October 20th, 2022, and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy, your client was referred to the probation department for PSI with a sentence recommendation. The court has received and reviewed that recommendation along with the police report, your client's criminal history and driving record. Was there anything you wanted to say on behalf of your client additionally, sir?
Nothing further, Your Honor. Sir, do you want to add anything else to the court? He indicates no, Your Honor. If you'd like to see him say it deliberately, I'll turn the camera around.
No, I take you at your word as an officer of the court. Mr. Zelenak, the court has two concerns. Both your client's BAC at the time of this offense, which was 0.282, and the fact that this is his second drinking and driving offense in the last 2 years. It's a great step in the right direction that he is engaged fully in the 25th District Court's sobriety court. And this court has no intention or desire to upset that apple cart. Wishes him every ounce of success in that court sobriety court, and will adopt the recommendation from this court's probation department. The recommendation of Stephen Hicks is that your client be placed on 24 months of probation. The court will assess a fine of $100, cost of $100, $75 crime victims fee, $50 mandatory state cost, $20 fund fee, $150 in restitution to the City of Belleville, and the monthly oversight fees for the probation department. That would be a total of $1,475.
I'm going to ask him if he can get in to pay that this week, sir. Can you get with he'll pay it this week, Judge. The reason is that with 24 months, there's no early out. And this is, as we learned in law school, the last clear chance doctrine for him. he's gone inpatient 3 times since was arrested on this offense. So this is where he has to go, or you'll be sending him down to the Folsom Prison Blues next time. And he's aware of that. I'd like to have him pay his costs immediately, so we'll take care of it this week, Judge.
He can get in contact with the court's collection department, or he can go online and pay it. The requirement, though, sir, is that you continue to comply and complete the sobriety program. Update this court's probation department as requested. If this court receives information that for some reason you are no longer being compliant in the 25th District Court Sobriety Court, we may have a different conversation. But for right now, this court wishes you much success with that court sobriety court. And if there's anything we can do to be of assistance or support, please do not hesitate. Mr. Zelenak, anything else this morning?
No, Your Honor, I appreciate your indulgence, and you allowed us to delay this case to get him in. This is his last nudge. It came from the court. If he doesn't do it, then he knows that all bets are off, and he's looking at a lot of time. This is, as you said, Judge, is an egregious case. And I thank you for giving us the option to get into this court. I appreciate the decency of the court and helping sobriety.
Thank you. Good luck to you, sir. You both have a wonderful day.
Thank you, Your Honor. We'll log off now, Judge. Thank you very much.
Thank you. That must be the new math. Ms. Rapp, my math was off. It is 14:55. The file will be down shortly.
Okay, Your Honor, I'll contact the court to see if you might have to sign a transfer order, but I will let you know.
Thank you. And that's it until 9 o'clock.
Morning, Josh. How are you?
There we go.
Can you hear me?
I can now. I had my computer itself was muted. Sorry about that.
Hi, that's okay. Good morning. How are you?
I'm good. So I did not get anything for any show cause or VOPs today.
Yeah, we
looking-
just sentencings.
Okay, I'm covering 3 for Dan today. I'm here
Okay.
on Mark Kuiper, James Taylor, and Edward Womack.
Yep. Okay, cool. Do you just want to sit? Yeah. Oh, it's almost 9 o'clock. All right.
Yeah, no problem.
Thanks.
I'll just mute myself, and whenever everybody's ready, I'll be here.
Okay. Thanks, Josh.
Good morning. Let's see, we got, okay, everybody's logging in. There we go.
Good morning, sir. Can you hear me?
Yes,
Hi. What is your name, please?
Mark Kuiper.
Thank you.
Thank you.
Mr. Hadley, do you need to speak with him in a breakout room or are you ready to go?
I can just speak with Mr. Kuiper real quickly. I think we're pretty much ready, though.
Okay. Mr. Kuiper, you're going to see an invitation to join the breakout room.
Thank you.
Good morning, Your Honor.
Good morning, Mr. Hadley. How are you?
Doing quite well. Standing in for Mr. Batar on a couple of matters this morning. And we should have Mr. Kuiper joining us in just a moment. I just had a chance to meet
Just
with him.
waiting for him to come out of the breakout. Yes, sir.
Yep. And then I was letting Mary Ann know, got one at 9:30 and one at 10. So we're all right up. Good morning, Mr. Kuiper. Can you hear us?
Yes.
Okay.
This is 22BL00188B. This is City of Belleville versus Mark Allen Kuiper. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the defendant, Mr. Mark Kuiper, standing in place today for Mr. Daniel Batar.
Thank you. Today is the day and time set for sentencing in this matter. Mr. Hadley, are you ready to proceed?
We are, Your Honor. I've had an opportunity to review the recommendation, and we do just have a couple minor points that we would like to raise, and maybe Shannon or Tony can help out. There was the issue of $150 of restitution to the City of Belleville. Just wasn't sure that we'd received any information as to what that was for. Didn't know if anybody else had any other insight as to what that 150 was restitution for.
That would be for housing.
Okay,
the
very
defendant.
good. We just knew that there wasn't a blood draw. I just wanted to make sure that that wasn't the case there. Your Honor, after speaking with Mr. Kuiper and Mr. Batar, we would ask the court adopt the sentencing recommendation with a couple of minor caveats. Based on the needs assessment and Mr. Kuiper's statements to both counsel and to the court, we think that the alcohol tether would be again, a little punitive and beyond the scope of what's necessary in this matter. And we would also just additionally ask that the alcohol education program be placed into some type of, I'm sorry, we would ask that the court adopt an alcohol education program versus like an outpatient treatment. Just based on Mr. Kuiper's specific needs, we think it would probably be more suitable. And with that, Your Honor, the rest of the sentencing recommendation, we take no issue, or the PSI, all factually accurate.
Thank you. Just as a preliminary matter, there was an offense date in this case of March 11, 2022 in the City of Belleville, at which time Mr. Kuiper was charged with operating while intoxicated. He appeared before this court on October 20, 2022 and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy, he was referred to the probation department for interview and the development of a sentence recommendation. Mr. Hadley, you've indicated that you have some issue with the alcohol monitor being punitive. Do you want to go into that?
Your Honor, I guess we understand that the purpose of punishment is in fact to be punitive, but we would state that again, based on the offense and Mr. Kuiper's personal circumstances, that it would be unnecessary. We think that random testing would be more than sufficient to ensure his compliance with probation versus the additional costs of essentially going through the tether.
And how frequently would you suggest for the random testing, sir?
The random part of it's always what we think is the key, but you know, as long as no one really has an idea. But I mean, with the ETG testings that they're being with the 72-hour look back, I feel like a twice a week on a random basis would certainly keep Mr. Kuiper honest and on the path of sobriety.
Ms. Rapp?
If the defendant is willing to test twice a week instead of doing 30 to 90 days on the alcohol monitor, I don't have no objections to that.
Greatly
Thank
appreciate
you.
it.
And Mr. Hadley, on the issue of the level 2 alcohol education program, you were suggesting something different, sir?
Well, and this is again, Mr. Batar and I had kind of gone back and forth, and yeah, basically asking, my understanding is that maybe it's my unfamiliarity with specifically this alcohol education program, but is that something then that would be different from our standard outpatient? Because what Mr. Batar and myself had discussed was that he was asking basically that an alcohol education program be what the court imposed, but it does to me appear that is in fact what probation's recommended. So yes, Your Honor, I would state that again, the alcohol education programming versus an outpatient treatment be the appropriate programming.
Okay. Well, Mr. Hadley, the court has had the opportunity to review both the recommendation from Stephen Hicks along with the police report and Mr. Kuiper's driving record. I know no criminal history. The court's concern is that your client operating a vehicle with a BAC of 0.14 and a weapon in the vehicle. That's more of an aside than anything else. The court will adopt the recommendation largely from Mr. Hicks, place Mr. Kuiper on 12 months of probation with the requisite oversight costs, assess a fine of $300, cost of $100, $75 crime victims fee, $50 mandatory state costs. There's a $50 show cause fee, $50 warrant fee, the $150 of restitution to the city of Belleville. There was a $15 administrative fee, $45 FAC. We will depart from paragraph 6 and the sentence will be 2 times a week testing in lieu of the alcohol monitoring. Mr. Kuiper will attend a level 2 alcohol education program or engage in substance abuse treatment beginning within 30 days of today's date and follow all recommendations and provide documentation to this court's probation department as directed. He will not purchase, possess, consume any alcoholic beverages during the pendency of his probation. And he will make payments on the fines and costs assessed in this matter, which total $1,335. Mr. Kuiper, this court wants you to be successful on probation. If there is something that you need along the way, if you're struggling in some way, you need assistance of the probation department, please do not hesitate to reach out to them and let them know what it is that you need. It's a lot easier for them to help you when you struggle a little bit versus being non-compliant and them asking the court to impose additional sanctions on you. Understood?
Yes, thank you.
Anything else, Mr. Hadley?
No, Your Honor, thank you very much for taking time to have an open mind to hearing out the allocution. We appreciate it.
Thank you, Mr. Kuiper. The probation department will be in communication with you to help you get your testing set up and get your payment plan established, okay?
Okay, thank you.
Thank you, sir. Good luck to
Have
you.
a
Have
good-
a good day.
Yep, you also. Thank you.
Thank you.
Yeah, my apologies on confusing that. When I was trying to read Dan's email, and I think I crossed up the programming. Shannon, just so I'm clear, the level 2 alcohol education program, what's the length of that usually? I think maybe I misunderstood that.
So the level 2 alcohol education program is approximately 18-hour program.
Okay. So that would be usually less of a responsibility than like an outpatient treatment.
Correct.
Okay, that Danzy, I understand what he was saying now. My apology. Yeah, my apologies for confusing that one with everybody.
Yeah, there's online classes for that, and then the in-person ones are usually like a Saturday, Sunday, and then a Monday evening to complete those hours.
Thank you. See, I learn something every day, Your Honor.
I think we all do. I saw Mr. Jadala pop on.
That's me, Judge. I was just waiting for Kelly Dameron for a sentencing.
Yes, sir.
Got a fun law school question going today, Your Honor.
Law
So
school question.
I've got an individual who I'm representing on a retained matter up in the city of Lapeer. I'm up here today. And two individuals were both ticketed under a fighting ordinance as like mutual combatants. And the city attorney is intending to argue that it's a strict liability offense, that I'm not going to be permitted to argue self-defense. Yep, I know. So I actually had to do like some legal research and break out, the old Westlaw this weekend. And I can't find a single precedent or statute anywhere that says that's how the thing works. Have you ever heard of anybody trying to say that there's a strict liability that you couldn't argue a self-defense claim?
No, I haven't heard that. And Mr. Jadala, I wonder if that's something that he's heard of before.
Yeah, maybe, because dealing with some of these ordinances are older and have never even really been challenged or don't get prosecuted very often, spitting on the sidewalk tickets and stuff. But I'm kind of curious. Yeah, we're gonna have to do a motion in limine to find out. Yeah, am I going to be permitted a jury instruction to argue self-defense?
You
Mr.
should be,
Jadala, can you hear
absolutely.
us?
I can hear you. And yeah, you
Yep.
absolutely should be able to argue that and get a jury instruction for self-defense. I don't believe that they can deny you. And I don't believe it's strict liability either.
Yeah, it seemed almost like I found some precedent with like felony firearms cases and things that were even further attenuated, from the actual offense, where they were still able to raise like an argument. It didn't work in the case that I found, but they let them try it. So I don't know. This will be an interesting one. I haven't had to write a brief and a motion in limine in a little while, so good practice.
Have they officially said to you, no,
The judge is not. So we're set today for a final pre-trial conference with all uppercase letters on final. And I think it'll be addressed today. We'll see. But the prosecutor just is the one who's intended that. He's like, well, no, it doesn't matter if there was self-defense claim. If they were, fighting under this ordinance, it doesn't matter. I said, so you're saying no self-defense claims inside the city?
there's something else to that story. There's some piece missing.
It's a bizarre one. Yeah, and sometimes you're right. Sometimes we find out a little bit later that there's another piece of evidence, but I gotta tell you, it doesn't look that way right now. The only, I guess, not even neutral third party, but third party to it was the girlfriend of my client, one of these co-defendants, and she's the only person who actually got punched. Like, she came in to kind of like try to break up the fracas, and the other guy socked her in the mouth. So I don't know.
I guess I've seen these true mutual combatant fighting ordinance cases end in dismissal. Very rarely is it, if it's truly both of them issued under local ordinance.
And I think that would be the
There's
proverbial,
something
like, what that's like, the meet me at the school, at the school playground at 4 o'clock and we're going to throw down. Like, that sounds like maybe mutual combatants. And the ordinance itself, it's got something that references like the only affirmative defense is if you're a licensed prize fighter with a permit. So, if it's a good old fisticuffs in the ring that everybody got, permits for, then that's okay to be mutual combatants. But anything short of that is a violation of this ordinance. So it's fun.
I have to remember to ask you the next time I see you what happened.
Yeah, I'm curious. And I'm up in Lapeer right now. So it's before coming down, I might start my own practice. I was up here for about 3 or 4 years. And this district court judge has seen a few of my antics with some of my Better Call Saul routines. So you never know what she's gonna do. I might be on my way to the circuit court really quickly.
Not Better Call Saul, which was a good show, by the way.
It is a good show. I actually pulled it a prelim. Thankfully, I did it before that episode ever aired. But my client was in the 3rd row of the peanut gallery for the prelim. And the assistant prosecutor pivoted on his hip and asked the witness to identify my client while pointing at the intern who was sitting at my conference table. I about got an overnight on that one. It's legal to do. I had to do my research. It was one of those things that I got taught that at a CDAM conference one time as like a baby lawyer. And they're like, there's nothing that says that for identification purposes, you've got to have them sitting at the table. So I said, let's just give it a whirl. I think I'll tell the judge before I do that next time.
Interesting. Because
And then-
I've seen it in different shows. I didn't know if anybody actually did it in real life.
Yeah, you're looking at the idiot who tried it. So let's just say we were still bound over, but the case worked out favorably. But yeah, that stunt didn't go quite as far as I'd hoped. Got to keep it
Did you need to
interesting though.
speak to Mr. Taylor?
Nope, I think we're ready to go. Is he
He's
logged
connecting
in?
right now.
Perfect.
He just popped into the waiting room. Good morning, Mr. Taylor.
Morning.
This is 20HR13716A. This is Huron Township versus James Philip Taylor. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the defendant, Mr. James Taylor, who's appearing via Zoom. Mr. Taylor, can you please state your name for the court?
James Philip Taylor II.
Thank you. Today is the day and time set for the sentencing in this matter. There was an offense date of July 24, 2020 in Huron Township, at which time Mr. Taylor was charged with operating a commercial motor vehicle with a BAC of 0.04 to 0.07, appeared before this court on July 14, 2022, and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy, Mr. Taylor was referred to the court's probation department for PSI with the sentence recommendation. He thereafter failed to appear as directed and bench warrant issued. He subsequently submitted himself to the probation department. The court has had the opportunity to review the PSI with the recommendation, the police report, needs assessment, review Mr. Taylor's criminal history. Mr. Hadley, was there anything you wanted to say on behalf of your client this morning?
Your Honor, we found the PSI factually accurate. We have nothing, no corrections or amendments there. Regarding the recommendation, we think it's a fair recommendation. As it relates to condition number 7, we would ask the court adopt a level 2 alcohol education program in lieu of the substance abuse treatment, and just state that Mr. Taylor looks forward to putting this matter behind him. I know he's spoken at length with Mr. Batar about this issue, and yeah, we would just ask for this court's understanding as you issue sentencing today.
Thank you. Mr. Taylor, was there anything you wanted to say on your own behalf, sir?
I'd just like to tell you, I understand the mistake that I made, and I plan on not making any other mistakes like this anymore. But I'm truly sorry and ready to move on.
Thank you. This court will adopt the recommendations set forth by Stephen Hicks of the court's probation department. Will place Mr. Taylor on 9 months of probation with the oversight fees of $360, impose a fine of $300, cost of $300. Their $75 crime victims fee, There's $241 of restitution to Huron Township. 75, I said $75 crime victims, $50 show cause fee, $100 in warrant fees, $50 state cost, $20 fund fee, $50 late fee. It's a total of $1,546. Excuse me. Mr. Taylor will also complete 48 hours of community service at a nonprofit organization with documentation to probation as directed. Mr. Taylor, you may use the entirety of your probation to complete those community service hours, but I encourage you to do them sooner rather than later. You will attend a level 2 alcohol education program, follow all recommendations with documentation to the probation department as directed, not purchase, possess, consume any alcoholic beverages during the pendency of your probation, and make equal monthly payments on your fines, costs, and oversight fees, which you may speak with the probation department about doing that. They'll be in communication with you about the alcohol education program as well. Anything else on behalf of your client, Mr. Hadley?
No, Your Honor, thank you very much for your court's time today.
Thank you. Anything else, Mr. Taylor?
No, ma'am. Yes.
Good luck to you, Mr. Taylor. If there's anything that you need from the probation department so you may complete your probation period successfully, please do not hesitate to reach out to them. They want you to be successful in this matter. Other than
Okay.
that, sir, good luck to you. Have a good day.
Thank you. You as well.
Thank you. So if the witness is the only one that was hit, where's
two guys
neutral
were,
come back?
So the facts as testified, or as I expect testimony to state, and then the police report pretty much corroborates, these two individuals found each other on a sidewalk. They'd had some kind of like social media beef. They see each other out in public. The other guy, not my guy, he's actually driving a scooter with his 4-year-old daughter, like sitting between his legs on a scooter. He pulls over, gets off the scooter, and confronts my client. They exchange words. The other guy, as it sounds like testimony will show, kind of like put my guy in a wrestling hold, and they just fell down on the ground together. It's kind of two overweight guys just like rolling around in the grass. And that's when the police just happen to be driving by, see this fracas, do a U-turn. They pull up, and that's right after the girl had pretty much gotten socked in the face. My guess.
Husband and I were just talking about this social media stuff last night, how people take this keyboard courage and turn it into real life fights and beefs and back and forth. And it is amazing to me. I read it. If I see something I don't like, I just
ignore it, move on. Yeah, I do not feel compelled to respond to people on that kind of stuff. I just don't get it. And you're right. I mean, we see a lot of cases, be it text messages or social media posts, where people, I mean, commit a crime. You're like, what are you doing? You can that's not free speech. Like, you can't tell somebody I'm on my way over to your house to beat the bricks off your ass. Like, you say something like that, and that's a crime. And it's just amazing to me that people behind the keyboard don't get that.
Well, this case is over now, but there was one where these people were they're fleeing from the police, and they were on Facebook Live, and they're back and forth showing their faces while they're fleeing. And I thought to myself, what were you thinking? How is that? I mean, it's job security for defense counsel and whatever else, but how was that ever a good idea? I'm going to show my face and the driver's face and go back and show the front of the police car while I'm actively involved in fleeing from the police.
With a pinging data point that can prove that it was like, this was me. Like, I think the science will back all of that up. It's nuts.
I tell people I see more search warrants for that kind of stuff, the different cloud storage and social media and your other phone related accounts than actual physical going to the house or sees the car or sees the body, because people feel a need to record every single second of every single day. Like that Jim Carrey movie where he was living in
The Truman Show.
why can't I think of the name of the Truman Show? Thank you.
Some good,
I find it
that was some
interesting
interesting
because when
commentary.
the prosecutor says, well, here's the video, and you watch it. What can you do?
And I'm going to a couple of those, CDM conferences where about 10 minutes into the lecture on like cell phone pinging and the technology, they lose me. But I understand the gist of it, which is these things, they'll tell you a lot of information about where somebody certainly was and what they were doing, how long they were there, which can be alibi evidence, or it can be awfully damning, incriminating evidence depending on the circumstances. But yeah, people are like, no, I turn off my GPS tracking. It's like, nah, you may have thought you did, but don't worry, your phone knows where it's at.
Not only where it's at, but what you're working on.
Yep. It's
Somebody
amazing.
slid me a note and said, search once for something you would never buy. Just kind of, so I did. And then I start receiving ads for it. Lots of ads for something I would never, ever, ever. And I thought to myself, that's a whole level of science and technology that I don't understand. I don't pretend to understand. Or if you talk about it, my phone's listening to me. I say I want this thing out loud, then all of a sudden,
Inundated with ads for it.
We're seeing the ad and it just,
I'm trying to remember what the documentary I watched on it, but it was about the group Cambridge Analytica, who they did a bunch of that data gathering, and yeah, they can predict all sorts of things about each one of us. It's a little spooky. Get my
and
aluminum.
The thought of some stranger watching your search history and whatnot.
I'm gonna have to get my aluminum foil hat back out of storage for some of these. Oh boy.
Good morning, Mr. Stetter.
Good morning.
We're just waiting for Mr. Cleary to arrive, sir.
Yeah, he said he'd be on about 15 minutes before.
Thank you.
Judge, I'm going to continue to try to get a hold of my client and log back in a few minutes, if you don't mind.
Absolutely. Thank you, Mr. Jadala.
Absolutely, Judge.
Good morning, Mr. Cleary.
Good morning, Your Honor.
Did you need to speak to Mr. Stetter?
I do not. I've spoken to Mr. Stetter several times.
Thank you. This is 220656OD. This is City of Romulus versus Timothy Allen Stetter. May I have your appearances, please?
Yes, again, good morning, Your Honor. For the record, Kevin Cleary appearing for Timothy Stetter.
State your name for the record, please, sir.
Timothy Allen Stetter.
Thank you. Today is the day and time set for the sentencing in this matter. There was an offense date of March 29, 2022 in the city of Romulus. Mr. Stetter was charged with operating while intoxicated. He appeared before this court on November 3rd, 2022 and entered a plea of guilty as charged. As is this court's policy with drinking and driving offenses, Mr. Stetter was referred to the court's probation department for an interview and the development of a sentence recommendation. The court has had the opportunity to review that recommendation from probation agent Stephen Hicks, along with the police report written by the City of Romulus Police Department. Review Mr. Stetter's criminal history, his driving record, his needs assessment, along with the letter from the Vaughn Center for Personal Growth and Development. Mr. Cleary, what would you like to say on behalf of your client, sir?
Thank you, Your Honor. I would start by saying that my client and I have reviewed the report prepared by the probation department. It is factually accurate. We have no additions or deletions to make to that report. And candidly, we believe the recommendation, all things considered, is certainly fair. And we're hoping the court is going to adopt it or something close to it. A few brief comments on top of that, Your Honor. As the court knows, obviously, this is my client's second offense. That is cause for some concern. One offense is cause for concern. Two offenses is certainly a lot more concerning. What I would like to point out is that he got them relatively quickly. And the reason I feel that's important is people learn from being on probation. Hopefully, I mean, that's the whole point, right? You know, you get yourself on the right path and learn from it. He was not on probation for very long when he picked up the second offense. And they did deal with this as a probation violation on his first offense in Dearborn Heights. In addition, I would point out that this particular offense happened about 8 months ago, a little over 8 months ago now. So he has had a significant period of time to learn from his mistakes, to figure it out while on probation to the other offense. And I truly believe he is on the right path now. The court recognized that and has acknowledged that it's received a letter from the Vaughn Center. A highlight or two from that letter indicates, and this isn't an excuse, but my client did undergo, because everybody has tragedies and grief to deal with. He had a couple of back-to-back significant things that happened to him that he did not process very well. And that is why he sought out the Vaughn Center, and that is why he has been counseling. And he was going through some intense emotional pain and reacted badly to that. But Pamela Vaughn has helped him establish new coping strategies, and he has done very well for a relatively significant period of time. So to sum it all up, Your Honor, I do believe the recommendation is an appropriate one. The only thing I would like the court to take an extra look at, 30 to 60 days on an alcohol monitor. My client is happy to prove himself to this court. He would do that willingly. He would do that for a longer period of time. I wonder if it's absolutely necessary at this point, due to the fact that this offense did happen 8 months ago. He has maintained sobriety during that 8-month period of time. He does have new coping mechanisms. He is not driving because his license is revoked, so he won't be driving for a relatively significant period of time as well. Thank you, Your Honor.
So, Mr. Clear, are you asking that the court not place Mr. Stetter on any period of alcohol monitoring?
Well, I'm just asking the court to consider if it is still necessary at this point. But again, I'd rather highlight by saying, Mike, I talked to my client about this, and he said, I'm happy to prove myself to this court. So the attorney in me is saying, do we need to do this? But big picture, certainly I get it, and my client gets it as well.
Thank you. Ms. Rapp, is there any comment you'd like to make on the request from Mr. Cleary?
Sorry, froze up for a second. I apologize. Since we don't have any documentation that I'm aware of that we have, the defendant showing no use of alcohol, I would recommend that at least 30 days on the monitor to prove that. In addition, because it is his second offense, although this was back in March of 2022, both cases are pretty close in 21 and in 22.
Thank you. Mr. Cleary, the court does appreciate the comments that you made on behalf of Mr. Stetter, and in reading the letter from Ms. Vaughn, I was moved by the fact that Mr. Stetter did have two really traumatic incidents in pretty short duration of time. And all of us, you know, we've had our not so good days, and most people don't have to live them out loud with strangers and own them in front of strangers. That's, again, more of an aside than anything else. You've already indicated that you believe that the recommendation by the probation department is fair. That being the case, the court will adopt the recommendation from Agent Stephen Hicks, place Mr. Stetter on 12 months of probation with the associated oversight fees, assess a fine of $500, cost of $100, there's $75 mandatory crime victims fee, there's $200 in restitution to the city of Romulus. Mr. Stetter will be placed on 30 days of alcohol monitoring at his expense. He will continue in his substance abuse treatment, follow all recommendations, and produce documentation to this court's probation department as directed. Not purchase, possess, consume any alcoholic beverages or controlled substances without the court's approval during his probation, and submit to random testing with a minimum of 2 times per month ETG, or as directed by the probation department. Total fines and costs will be $1,425. He will make regular monthly payments on these fines and costs. Mr. Stetter, the court's wish and hope for you is that you're successful in probation with this court and with the other court. And if there's anything that you need from this court's probation department to be successful, please do not hesitate to reach out to them and let them know what it is you need, what support you require to be successful. Anything else, Mr. Cleary?
Nothing on this matter, Your Honor. Thank you.
Thank you. Mr. Stetter, good luck to you, sir. Have a good week, okay?
Thank you, Your Honor.
Thank you, Judge.
So I thought about you yesterday, Mr. Hadley, because I'm back on social media. I see a house that has 7 Great Danes in it. And I thought about you with the dog. I think you had Mr. Nunley's dog behind you the other day. 7. I cannot imagine that.
7 Great Danes. I'm just thinking about the amount of food and then the amount of what comes after the food. That's a lot of dogs. I had 3 big dogs. It's the most I've ever kept at one time. It was a pit bull, a boxer, and a Akita, and that was too much. 7, that's, God bless them.
Our dog's breeder had 5 Great Danes at the same time, 5 adults. And I'm trying to think, why did we go back? When we went to actually pick our dog up, she had 2 of her previous dogs back to deliver their puppies. That's what it was. She had 24 puppies in addition to her, because that was her thing. She said, if you breed her dogs, she's happy to take them back and help you get the puppies through to the stage of being able to be sold or rehomed or whatever. She posted a picture one day of the back of her Yukon that just had stacks and stacks and stacks of bags of dog food. And I think 24 puppies.
Yeah, that's
in
so
addition to her
much.
she had an almost 200-pound 4-year-old. This dog was my dog's grandmother. So almost 200-pound beautiful dog. But I'm thinking to myself, same as you, the bags of food and what comes after the food.
Then the bags is something else that comes after that. That's a lot of animals. I mean, I guess the upside would be I guess with Great Danes, you've got a Great Dane, then it sounds like, right? Okay, so they're not like spaz super high energy dogs though, right? Aren't they kind of a little more chill?
Fits and spurts. She still gets the zoomies, but
Okay.
those, there's few and far between now.
I'm just thinking of a small pony having the zoomies like running around a house. And then I'm thinking of like the doorbell ringing and having 5 of them do it or something like that. It's like that's kind of people get knocked over left and right.
I can't even, they were so chill. Whoever these people were, they had these giant dog beds. It looks like a den area, and they were just kind of meandering around, laying down. And the thought of, I know what our dog is like when she leans against you. I can't imagine this whole tribe of dogs.
Yeah, doorbell rings, and then that's probably a lot of a lot of barking.
That's why I tell people, I'm like,
think-
please don't ring our bell. If you just text me and let me know you're here.
I'm on
'Cause
my
once
way
you
to the
ring the
door.
bell, it's, yeah. You had 3 big dogs at the same time?
We did. I mean, the pack mentality kind of helped a little bit, but yeah, certain things. We were in Arizona at the time, and the rental we had came with the pool service for the pool. But that poor guy, I don't know what he was thinking, but he just let himself into the backyard the one day because he had a key. And we came back to see him cornered with like the pool skimmer, kind of like waving it back and forth. To get your dogs away from me. I said, I'm not sure I want to. What'd you let yourself in my backyard for, you dum dum? Like the law of self-preservation would say you'd look over that fence and say, I don't think I should probably go in there. And they were all friendly dogs, but when a stranger comes into the backyard, they're gonna do what they do.
We used to have a neighbor that had a not Great Dane, German Shepherd. This dog, you could hear bark like 4 or 5 doors over. You could not step on these people's porch. You couldn't go in their yard. But they had 3 little boys who played in the front yard. Drake was the dog's name. I had to think about it for a second. These kids would like wander down towards the street. Drake would come out, nudge them back onto the lawn. It was amazing. He was so gentle with them, but when they were coming to replace the water meter, the guy started walking up to the house, and I happened to be outside, and I'm watching this thing unfold, thinking to myself, this guy's about to meet Drake in a way that's not going to be pleasant for him. But
No. Yeah, my cousin is a police officer down in I guess that's Boone County. It's like the northwest side of Indianapolis, Zionsville, Indiana. And his I think he just transferred out of it, but he was in the canine unit for about 6 years. And I think he cycled through 2 different of those shepherds. And yeah, I mean, the way they're hardwired, and then with training and everything else, they're pretty amazing dogs. I don't know that I would want a German Shepherd, but they're remarkable what they can do when trained and handled well.
the Shepherds and the Belgian Malinois, I see the video of them with the trainers. They're just little hand signals or noises, and the dogs are coming to complete stops or doing these circles or whatever else. It is truly amazing.
Yeah, they get them running on a dead sprint, and they can pull up just short of whatever they're running at.
And it looks so nice. And then I think of our dog who lays on the couch and watches TV all day. Complete lack of training, complete free spirit is what I call our dog. So
it's a good dog life.
I want that life. I want to be able to lay around people, take you out when you want to go out, ride around with your, the wind blowing in your face, ears flapping in the breeze.
Yeah, I think by the time I get to that point in my life, I probably won't know where I'm at anymore. Somebody's coming to pick me up and driving me around.
We're just waiting for Mr. Jadala, if he had any luck with his client. Ms. Rapp and Mr. Grant, I think we're almost done. Have 10 o'clock. Are you covering Mr. Batar's 10 o'clock?
I am, and I can give Shannon or Tony a heads up, because Mr. Batar did raise an issue on that one. If you guys want to get ahead of it, he did ask. Let me just go right to the email so I'm not misphrasing it. There's a restitution issue in this one, and Dan stating that he did not receive the documentation in support of the restitution as indicated in the PSI.
You didn't receive the letter from Mr. Greco with the information about the repairs to the patrol car?
No, he didn't. So
Okay.
I don't know. We might be able to get that cleaned up if anybody has any supporting evidence. Does the court have it? Did Mr. Greco send a copy of it to you guys?
I have it and I've reviewed it, and that's why if we have time, if Ms. Rapp sending it to you would be sufficient, or would you like to be able to send it to Mr. Bitar and reschedule? Doesn't matter.
No, I think that as long as there's supporting documentation, I don't know that there was a challenge about the restitution in itself, just that he hadn't seen anything in support of it. So, yeah, I think if maybe somebody can email it to me, I can meet with Mr. Womack really quickly and just explain to him where the amount came from. And Your Honor, I love this one on the court rule. When they made the changes back in August, I think it was when it was amended. Yeah. On MCR 6.430, which is the post-judgment motion to amend restitution, it used to be a bear. Remember, you used to always have to deal with restitution like at the time of sentencing. This
Right.
kind of changed it a little bit, is my understanding, because I've had to argue it in a couple of my Sado Max like appeals. But basically, under the Crime Victims Act, as it was interpreted with this court rule, the prosecutor, the victim, or the defendant, at pretty much any time that they have new information, and that would be documentation, you can go back and have an amendment hearing on that restitution issue. Because it used to kind of be like put up now or forever hold your peace. But I think that I don't know what the motive was behind them changing this, other than maybe to not slow down sentencings. I don't know. But I did have it come up in one of my appellate cases where I was like, I didn't realize the court rule had changed. So yeah, a defendant can come traipsing into court like now, I mean, in theory, like 6 months after the whole case is done and been like, hey, I found that missing, medical bill from when I got my jaw broken in the bar fight, and restitution could be revisited.
But how many other people haven't seen that either, or
The
would
court
know
of
how to get back in front of the court?
and practically, I don't know. Yeah, it's not like the ICL, the ICLE, or even through CDAM. I don't remember seeing, usually when court rules change, they send out a big, hey guys, this is relevant to your practice, check it out. The only reason I stumbled on this was it was one of my appellate cases, and we were just grasping at straws looking for, anything. And we realized that the restitution back in 2016 or 17 had no supporting documentation. And we're able to still challenge it from 6 years prior under the new court rule. So it does make things a little bit easier sometimes if you just say, we haven't heard from the victim yet, but we want to get sentencing done with. If they come forward later, then great, we'll hit you with restitution then. Oh, we got Mr. Womack. All right.
I don't know, Ms. Rapp, did you have the opportunity to send that information to Mr. Hadley?
I can, Your Honor. Sorry, I had walked up and I was dealing with a video arraignment, so I did not catch that. I will
Oh, I'm
send that.
sorry.
I will get that scanned in if it's not with you. Give me one moment.
Yes, ma'am, thank you.
Mr. Womack, just sit tight for one moment. The probation department is sending me over some documentation, and then you and I are going to meet briefly in a breakout room before we see the judge for sentencing, okay?
Sounds good.
Thank you, sir.
Mhm.
Your Honor,
Ma'am,
I believe the restitution is amount with you in the court file. Did you want me to come up and make a copy? That's just what I was told. I can go make a copy.
I have it. I'll bring it down to you.
And then I can scan that in.
Thank you. I'll see you in just a second.
Josh, I just sent that to you.
Hey, Shannon.
Yes,
So what Dan had mentioned to me was, I think that the police report had a mention of $1,000, and then there was an 1150.
yeah, in that email. Did you,
Yep. So, oh, I see it now. I'm sorry. I just opened the attachment. I didn't read. Oh, okay.
yeah,
So it's 1,000 for the restitution, then the 150 for the police fees. Okay.
yeah,
All right. I'm reading the supplement, and I think that we have no contest to the $1,000. So I just need to speak with Mr. Womack real briefly. So my understanding then, I just looking at all this, but basically it's just he's covering the $1,000 deductible.
from what I'm gathering is,
Yep, I see it now. I see the total, because I was looking for
yeah, it's like on page 5.
5. Yep,
Yeah,
perfect. Thank you for pointing me the right way. See if I can move Mr. Womack myself. Mr. Womack, if you can hear me, I'm going to be sending you an invite. It's going to say join, so you and I can meet in a breakout room really quick, okay?
Okay.
Maybe not. Let's try that again. There we go. All right. Did you see the invite come up on there on your screen yet? Here we go. Okay, we are all set to go on Mr. Womack, who will be joining us back in just a moment.
Thank you.
Yes, Your Honor.
This is 220654 OD. This is City of Romulus versus Edward Alexander Womack. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the defendant, Mr. Edward Womack.
Sir, state your name for the record, please.
Edward Womack.
Thank you. Today is the day and time set for sentencing in this matter. There was an offense date of May the 14th, 2022 in the city of Romulus. Mr. Womack was originally charged with operating while intoxicated. He appeared before this court on October 20th, 2022 and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy with drinking and driving offenses, he was referred to the probation department. They have done an interview, made a sentence recommendation. The court has reviewed that in its entirety, along with the police report in this matter, the request for restitution from the city of Romulus. Mr. Womack has no other criminal history. Court reviewed his driving record as well and his needs assessment. Mr. Hadley, what would you like to say on behalf of your client this morning?
Your Honor, after speaking with my client, Mr. Bitar, about this matter, we have no corrections or objections to the PSI. I also had an opportunity to review the documentation in support of the restitution. We have no objection to the restitution amount. In the way of allocution, again, Mr. Womack is addressed and is looking forward to addressing the issues that caused this arrest. We would point out, as you mentioned, the lack of prior record. And as it relates to condition number 7 on the recommendation, where the court's been provided either a level 2 alcohol education program or an outpatient substance abuse, we would request that the court adopt the level 2 alcohol education program for Mr. Womack. And again, he looks forward again to complying and getting this matter put behind.
Thank you. Mr. Womack, is there anything you'd like to say on your own behalf, sir?
No, Your Honor. I want to thank Mr. Bitar, Mr. Hadley. They've been very thorough, and I don't have any objections either.
Thank you. As indicated, the court did have the opportunity to review the police report in this matter. And Mr. Womack, you should consider yourself extremely lucky that no one was injured in this. He struck a stationary police vehicle that had its lights, its emergency lights illuminated. But again, and aside more than anything else, the court will adopt the recommendation of Mr. Hicks, place Mr. Womack on 9 months of probation, along with the oversight fees associated with that. Court will impose a fine of $300, cost of $100. There is a $50 mandatory state cost, $20 fund fee, $75 mandatory crime victims fee. There was a $150 restitution to the city of Romulus for housing. There was another $1,000 restitution to the city of Romulus for its deductible for the repairs to the police cruiser. Mr. Womack will complete 48 hours of community service at a nonprofit and provide documentation to the probation department. He will attend a level 2 alcohol education program, follow all recommendations from that program, and submit documentation to the probation department as directed. Not purchase, possess, consume any alcoholic beverages during the pendency of his probation, and submit to random testing at least twice per month with ETG. Mr. Womack, you will make regular monthly payments on the fines, costs, and oversight fees associated with your probation. The court's hope, sir, is that you are successful on probation. That means that this court's probation department will do what it can do to be supportive of you as you go through these 9 months of probation. If you need assistance in finding some place to do your community service, please reach out to the probation department. They will be in contact with you to establish your payment plan and to execute the paperwork needed to put your probation requirements in place. Mr. Hadley, anything else on behalf of Mr. Womack?
No, Your Honor, thank you for your time today and wish Mr. Womack the best of luck.
Thank you. Mr. Womack, thank you for joining us timely this morning. Good luck on probation, sir. Have a wonderful week, okay?
Thank you, Your Honor.
All right, Your Honor, Mary Ann, Shannon, everybody, thank you very much. Do you have, I think that was all I had for Dan today, unless there's anything else that's kind of hanging around that you guys want me to cover?
No, that's it. That was it for you, Mr. Hadley. Thank you. I was just wondering if Mr. Jadala had come back. His client is the only failure to appear we have this morning.
Well, I will, yeah, if you guys need to reach me, I'm gonna go run over and do the mutual combat and real quick. And then if Mr. Jadal or anyone does need coverage, I'll be back to my desk here shortly.
Thank you, sir.
See you,
Have a great day,
Judge.
everybody. Bye, everyone.
Mr. Jadala,
Yes, Judge. Has Ms. Dameron
Any-
appeared at all?
no. This
Your Honor,
is,
yeah.
this is 220661. This is City of Romulus versus Kelly Lynn Dameron. Today was the day and time set for the sentencing. Sentencing was actually scheduled at 9:15. It's now 10:12 by this court's clock. Mr. Jadala, any luck in reaching your client?
Your Honor, I've left text messages and voicemails repeatedly from Friday till today, and I have received no callback or no response at all. I have no reason for their non-appearance or non-response.
Thank you. Based on Ms. Dameron's failure to appear for sentencing this morning, bench warrant shall issue 5,010%. She has some other outstanding issues with this court. Anything else, Mr. Jadala?
Nothing further, Judge. Thank you.
Thank you. Have a good day, sir. Good luck to you.
To you and your staff. Thank you.
Anything else, Ms. Rapp?
No, Your Honor.
Thank you. I'll be down with your file shortly, ma'am.
Thank you.
And Mary Ann, that's all we have for the day.